In the latest drop, we learned that Twitter specifically targeted Dr. Martin Kulldorff, a prominent epidemiologist and former Harvard School of Medicine professor. Dr. Kulldorff is also one of 3 co-authors of the Great Barrington Declaration. His crime? Not towing the party line regarding COVID-19 and saying that children and those with prior COVID infection don't need the vaccine. Apparently, he believes in natural immunity. Imagine that. Of course, he wasn't alone in being targeted. Dr. Jay Bhattacharya, a professor of medicine at Stanford University and fellow author of the Great Barrington Declaration, was throttled by Twitter too. Well, neither Kulldorff nor Bhattacharya were willing to take Twitter and the government's overreaching lying down. They joined the Missouri and Louisiana suit challenging government-directed social media censorship and hired Jeanine Younes, a litigation counsel at New Civil Liberties Alliance, to represent them. And joining us to discuss this is Jeanine herself. Jeanine, thanks so much for joining us. Great to have you.
Thank you so much for having me.
First off, can you explain Dr. Kulldorff and Bhattacharya's case and its significance?
Yeah, so Drs. Bhattacharya and Kulldorff are claiming that they were censored on social media extensively, their ideas, and that censorship didn't happen because the social media companies wanted to do it, but because the federal government coerced and pressured the companies, threatening them with regulation or other legal consequences if they didn't censor people for spreading so-called misinformation about COVID. And of course, we know misinformation is just a term used to sort of make ideas that are different from the government seem as though they're not, they're crazy.
And in this latest Twitter Files drop, we learned specifically that Twitter targeted both of your clients. So how does that revelation help your case?
That's a really good question. So it definitely is helpful. I mean, to show that our clients were specifically targeted. Judges in similar cases in the past have basically said that there wasn't enough evidence that specific individuals were censored because of the government. The companies maybe would have done this on their own. Now, I don't actually think that that's a correct interpretation of the law. I think that our clients should have been able to establish First Amendment violations regardless of whether or not they were specifically mentioned, but it definitely helps, and it helps overcome that hurdle. So in a way, this is good news for our lawsuit.
And Jeanine, what is your opinion of all the revelations revealed in the Twitter Files? Do they count as a smoking gun potentially?
I think that the latest drop I actually would call a smoking gun. So what so far what the government has been saying is that, well, the companies want to do this. They want to be censoring people. They want to help the government. Now, again, I actually don't think that they should be able to do that. I think that's a First Amendment violation if the government and the companies are working together to censor people based on their viewpoint. The First Amendment says that the government can't censor people based on their viewpoints, and likewise, the government can't use these private companies as intermediaries to accomplish what it couldn't do directly. However, when you have coercion, it's an even stronger, clearer case. So the latest Twitter Files, one of the emails was an internal email that's sort of summarizing what had happened in a meeting, and a Twitter executive said that the White House was extremely angry with Twitter for not censoring misinformation more. They didn't know what to do, and I think that's direct evidence that this censorship was happening because of the government. So I would call that a smoking gun, actually.
And the Twitter Files have been largely ignored or dismissed as a nothing burger by much of the legacy media and many left-wing pundits. What do you make of all of that?
Well, it looks very bad politically for the White House. And obviously, we know a lot of left-leaning pundits are Democratic voters. They probably want Biden to win the next election, or at least a Democrat. And this looks really bad. I mean, you have the government violating people's civil liberties en masse, their First Amendment rights. That's very serious. So I think they're trying very hard to downplay it. But this is a very serious matter. I mean, we've never had government censoring the voices of Americans. Our clients are top epidemiologists whose voices were censored on the subject of their expertise. That's crazy when you look at it, but then lots of regular Americans who just had different opinions about COVID, and many of them turned out to be right, were censored. So this skewed the debate. It made it appear that there was a consensus that we should have lockdowns, mask mandates, vaccine mandates, when actually many people, scientists and not scientists, were disagreeing.
And Janine, as a lawyer, do you think the revelations warrant further legal action against Twitter and the federal government?
That's a really interesting question. So my office only sues the government. We don't sue private companies. I will say, under state action theory, if the private company is sort of working as an arm of the government to accomplish these unconstitutional aims, then in my opinion, they should be able to be sued as government actors. So I think that this will actually bring forward a spate of lawsuits. And people, like Alex Berenson, people may have heard of. He was a New York Times journalist, former New York Times journalist who was suspended by Twitter at the behest of the government. He sort of has the other most direct evidence, where you have emails between Twitter employees saying that the White House was pressuring them to censor Berenson. Now, someone like him, he made some money, generated an income, he sold books that he promoted on Twitter. He might be able to sue for money damages. And so I think that you could have people like that bring forth a lot of lawsuits.
And on that note, do you think new legislation is needed to ensure that we never see a repeat of this kind of government-directed censorship again? Or do you think that existing laws and Twitter being in new hands is enough?
That's a really good question. I think it depends a little bit on how these court cases turn out. So there's the Missouri case. I actually have another case that's quite similar in the Southern District of Ohio. If courts recognize that this is a First Amendment violation, if they draw a line and say, no, the court, the government cannot work with private companies to censor Americans for expressing, again, disfavored views that are frowned upon by the government, then I think that may be enough. And, I think sometimes more regulation tends to be abused. It often can end up accomplishing the opposite of what it's supposed to. But if the courts don't protect the rights of Americans in these circumstances, then I think I would probably support legislation as the only step forward.
And very quickly at the end, what's next for your case?
So we are deposing the former White House press secretary, Jennifer Psaki, in January. We've had a number of depositions, including of Anthony Fauci. We've gotten discovery in this case, which has sort of revealed a very high level of collusion between the government and big tech. So we hope to get a ruling on our emergency preliminary injunction motion sometime in the early spring or late winter. And so that's what will be happening next.
Well, we'll be following your case very closely too. Janine, thank you so much.
Thank you.